Good evening. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to another edition of Talking Point. My name is Fahraaz Patel. We'd like to thank you for staying with us here on Hilaal TV channel 347. Tonight we are going to be discussing the current status of Muslim marriages in South Africa and the proposed way forward. Of course, there is a draft bill for Muslim marriages, and that, of course, includes the Divorce Act. It is a topic of great controversy, but also at the same time one that needs in-depth analysis. And for that, I'd like to welcome Farhana Ismail. She's a specialist in divorce and family law, and she carries many other titles. Let me welcome her here. Farhana, assalamu alaikum wa rahmatullahi wa barakatuh. Jazakallah so much for joining us.
Walaikum salam wa rahmatullah. Thank you for having me.
No, it's an absolute pleasure. Okay. Farhana, we need to start off, of course, there is such confusion on this topic. I myself don't even understand it, and that's the reason why we've brought you, because you have over 2 decades of dealing with this here. Let's look at the background in what transpired and where are we now, because there's obviously the past and there's the present and there's the future. So let's delve into that.
Okay. So I think that, the issue of Muslim marriages in South Africa has been a long-standing debate over 20 years. The government and various other sectors have tried to resolve the issue through various bills, amendments, and so forth. However, has been unsuccessful until, I would say, December 2020. It's been a hot topic in a sense where Muslims are subjected to the laws of the country, which would be subjected to the laws of the country, which ultimately would mean that, it in certain instances would be going against the tenets and the framework of the laws of Sharia. So the Muslim personal law bills were drafted, and over years there were many drafts that went back and forth between government and public sector and other interested groups that were stakeholders in the issue. However, due to the opposition to the various bills, to the various drafts and legislation over the years, the MPL was thereafter scrapped and the marriage bill was scrapped. In 2014, which was the turning point, I would say, when the WLC, the Women's Legal Center from Cape Town, launched legal proceedings in respect of certain issues. I'm not going to get into the merits of those cases. Ultimately, what it encompassed was to have the rights of Muslim women recognized and Muslim marriages recognized. That was the turning point in our history where the courts now decided that government needed to take a standpoint. So the cases obviously argued from 2014, and that up until 2020, that led to the landmark judgment, which happened which was delivered in December 2020.
Farhana, before we talk about that landmark judgment, both you and I are South Africans, we enjoy so much of the democracy that has been given in this country, despite all the challenges that have happened. Do you think the government's been fair or unfair to us as Muslims with regards to the way we need to conduct marriages? Because it's an important point that you put up, that we need to follow the tenets of Islam.
I think that as Muslims, we are guided by our beautiful deen, Sharia. And the position that we find ourselves in, for me personally, is because Muslim women have not been advised of their rights at the commencement of the marriage, which ultimately leaves them in the situation that they're facing upon divorce.
Sorry
which
to
is not very
interject there,
Yeah.
Farhana. So who should be advising the Muslim woman at this time?
So, we've got several bodies of ulama. We've got very many learned people in society that know about the laws of nikah, in the laws of talaq, etc. My one concern is prior to marriages being concluded, not many, I would say majority of the people that enter are so excited about the wedding day and the engagement and the honeymoon that they forget that, you can enter into a nikah contract. Because if that nikah contract is entered into and it's regulated and properly drafted, a lot of the issues that women experience at the time of divorce would be eliminated. So one of there are a lot of individuals now and ulama bodies that are now seeing the need to draft these nikah contracts, which obviously, as I said to you, it would be at the commencement of the nikah. And I think that, that's a starting point that everybody should look at. The result of this judgment is because we do not educate not only our women, our men as well, in terms of their rights and obligations at the commencement of the nikah. So if we can cure that, I think half our battles are solved.
You bring up an interesting point there that education is important because everyone rushes on the wedding day, so beautiful and romantic on that time, but regulations and following our deen and following the tenets of it is important, isn't it? Because before that contract is signed, there has to be a thorough understanding, is there?
Most definitely.
But that's something that a lot of people getting married just seem to be blindsided about.
Look, times have changed.
Yeah.
It's no longer where marriages are arranged. Even though it's not Islamic, but the prospective husband and wife know each other. The families know each other. They know what they're getting themselves into most of the time. Can't say all of the time. And that is why it's important that families sit down and talk and have these open discussions. A lot of the cases that has come forth in the recent years, which also led up to the judgments that we have now, is because women at the time, in the older days, would just made the nikah and, they had children believing that marriage is forever, because that's what we all think, marriage is forever. Nobody ever thinks that 20 or 30 years later that I'm going to be divorced and I don't have anything in my name, because in the old school is that the man always provided.
Yes.
And the latest trend, which is again doesn't go against the teachings of Sharia as well, is that men are getting second wives. And then that also impacts on how the first wife needs to be maintained and children need to be maintained. On the death of the husband, what happens then? So those are a lot of, some of the issues of a lot of the issues that needs to be canvassed, needs to be spoken about, that is only coming to the fore now. It's unfortunate that it's only coming to the fore now because women's groups have taken it to court. It should have been done a long time ago.
But with that happening, Farhana, I mean, there is progress. I know it's not complete progress, but slow progress that is happening, isn't there?
What the judgments that have now been passed. So, I spoke to you about the Women's Legal Center that went to court now in 2014, and that led up to the 2020 judgment, where the Supreme Court of Appeal delivered, as I said earlier, on a landmark judgment. And in that landmark judgment, several pertinent points were made in terms of the South African legislation. Some of the points included that the Marriage Act and the Divorce Act, certain sections of it were inconsistent and unconstitutional because it did not include Muslim marriages. Certain sections of the Children's Act were also unconstitutional because it did not include children born of a Muslim marriage. Certain sections of the Divorce Act were unconstitutional because it did not include Muslim spouses. Now, whilst the court may have declared that it was unconstitutional, as Muslims, we need to then determine whether the unconstitutionality thereof is actually in line with the Sharia. Whether it, at the end of the day, we are not bound by the Constitution. We are bound by the laws of our deen. So, for example, because we've had many cases where women were now, after 20 or 30 years, given talaq, and they've got nowhere to go, no brothers, no fathers, they've got no support structure. The laws of Sharia dictate that the woman must be maintained for her 3-month iddah period, and then the right of maintenance reverts to the father or the brothers of the woman, which in reality is not happening. Child maintenance has also become a huge issue. Domestic violence has become a huge issue in our communities. And for that reason, the courts took a hard line. And a lot of the clauses of the judgment, and one in particular stands out for me.
Farhana, I'm going to ask you that one that stands out for you after the break, because we have to go and for that ad break. But after that, we will continue this discussion. I am in conversation with Farhana Ismail. We're discussing Muslim marriages and, of course, the various amendments and drafts that may or may not affect it. Do stay tuned. Welcome back to Talking Point. I'm in conversation with Farhana Ismail, attorney and specialist in divorce and family law. Farhana, Maaf, you were continuing with one of those clauses that came from the December 2020 judgment. Please do continue.
Yes, so one of the very important clauses that everyone was quite surprised and shocked about was that the Muslim marriages were subject to Section 7 of the Divorce Act.
Yeah.
And what does that mean is that Muslim marriages, either spouse in a marriage would then be entitled to a redistribution of each other's assets, because that is in line with the South African law. While that is in line with the South African law, it obviously is in conflict with the laws of Sharia, because as we know, the laws of Sharia for a man and a woman, when you do get married, is what's yours is yours, what's mine is mine. So just for an understanding insofar as the South African secular law goes versus the Sharia law. In Sharia law, as we said, it's what's yours is yours, what's mine is mine. Whereas in the South African law, you have 3 marital regimes that you can elect to be married under. So the one would be in community of property. The second one would be out of community of property without accrual. And the third would be out of community of property with accrual. I'm not going to get into the complications of the 3 different types of marital regimes. However, what the judgment then meant for us Muslims is that at the time that the judgment was granted, it said that pending the outcome of new legislation to be drafted by the legislature and parliament, or pending the amendment of current legislation, Muslim marriages would be subject to the Divorce Act and would be deemed to be out of community of property. Okay. However, if it was subject to the Divorce Act, certain clauses of the Divorce Act and certain relief in the Divorce Act could be granted to Muslim spouses. The one, as we said, would be the redistribution of assets. The second would be that either spouse would now be entitled to claim spousal maintenance from the other spouse. So, generally it is always a woman that would claim the maintenance. But there are exceptional cases where women are the breadwinners and men would be entitled to those, to claim the maintenance. The other clauses that were in the judgment was that children born of Muslim marriages were now subject to provisions of the Children's Act, and their names also, both the mom and dad's names, needed to be on the birth certificate and so forth. The issue of the redistribution of assets and the issue of spousal maintenance obviously is not within the framework of Sharia once again. So those were the two, I would say, two of the main issues that stood out for most of us that practice family law, because we needed to determine whether we were now subject to, following now what the courts have imposed on us of South Africa, or as Muslims, what do us as practitioners do?
And that's why I want to bring it in, because I want to look at two sides of the coin. So you've mentioned the three marital regimes. As a practicing lawyer and as somebody who deals with divorce, have you had cases where couples or even one of the two within the marriage use the South African regime as something for their convenience? Because we do know that money and materialism does play a part. We hope that it doesn't play a full part in marriages, but you do get cases where it is like that. Have you seen that happen, where it's been used for their own convenience?
Look, there are times that this happens, where couples elect to rather adopt the South African legal process in the dissolution of their divorce after having issued the talaq, because there is a civil marriage that has been registered and they need to dissolve the civil marriage. But at the same time, I think it's not as easy as that. One needs to look at certain factors as to why a person or a woman would want to follow the South African law, or why a man would want to follow the South African law. So, for instance, many men in situations of divorce would go to a children's court because women are now being difficult in allowing them to exercise contact with their children. Women, on the other hand, would then approach the maintenance court because the husband now all of a sudden is not fulfilling his maintenance obligations towards the children. And that depends on a variety of factors. It depends on what would the standard of living have been of the parties prior to the divorce. So as I said earlier on, we have a lot of couples that are now divorcing after 20 years or 30 years of marriage. And a woman is left penniless because all the assets are in the husband's name, all the, the vehicles, investments, etc. She doesn't have a monthly income. She depended on everything that he gave her. And all of a sudden, she finds herself without anything. So naturally she would go, to the courts for relief. And as I said, it depends. The other factor would be the age of the parties. I did say the standard of living. If either party is earning, what is their financial contribution towards the household? You'd have one of the parties that needs to move out of the marital home. They need accommodation because they don't have a family to go back to. So, the list it can carry on. So, I don't think I can sit here at this stage and probably say whether I think they justified or not. It depends on a case-to-case basis.
Farhana, let's speak of that constitutional court and their actual findings, because there were various layers and, of course, clauses to it. So let's talk about it. And, of course, maybe let's pick out the ones that you found to be of interest and, most importantly, important.
So what happened with the December 2020 judgment was one of the orders that were granted was that certain sections, as I said, of the Divorce Act and the Marriage Act were found to be unconstitutional, and it was referred to the Constitutional Court for confirmation. When the Constitutional Court heard the matter, they confirmed that these sections, which included the right to dignity, because Muslim marriages were not being recognized, and it was not part of the Marriages Act and the Divorce Act. So the Constitutional Court found that that was an infringement of the right to dignity of Muslims. Constitutional Court did also find that Section 7 of the Divorce Act and Section 9 of the Divorce Act, which deals with the redistribution of assets and forfeiture of assets from one spouse to another, was also unconstitutional in that it did not make provision for spouses in a Muslim marriage. So those clauses as we stand now, those provisions of the Divorce Act and the Marriages Act now apply. I would think those were, for me, those were the most important provisions that stood out. The other very important provision or order that the Constitutional Court alluded and made is that they were giving Parliament again a time period within which to get their house in order so that the issues and the disputes relating to Muslim marriages would now become more regulated and sorted out. Unfortunately, it hasn't really turned out the way we wanted it to turn out, because in enacting new legislation or amending the current legislation, once again, for us as Muslims, for me, I would say the majority of the ulama bodies and Muslim scholars and Muslim professional attorneys as well, we find that it's inconsistent and it goes against the teachings of the Quran and the Sunnah.
And that's where our next part of the program will be focusing on the draft marriage bill and, of course, the opposition towards it. Do stay tuned to Talking Point. Welcome back to Talking Point. I'm still in conversation with Farhana Ismail. Farhana, let's now speak of the draft marriage bill. I remember I made a phone call to you a couple of weeks ago and you said that 12 minutes would not suffice because there's so much to speak about. And we have Talking Point, and this affords us the opportunity to talk on this on a much more in-depth scale. There's tons of opposition to it. You know of fellow Muslim legal professionals who themselves are opposed to it. You mentioned that before we went to the break of that opposition. What is it about it that gives the opposition to it? Because, again, we have to remind the viewers that we are following the tenets of Sunnah and the tenets of the Holy Quran. And this right over here is in direct opposition to what the draft marriage bill is.
So what the draft marriage bill seeks to do is to bring all marriages under one umbrella, irrespective of race, religion, color, ethnic group, whatever the case may be. So what is trying to be achieved is that everybody follows one law when it comes to the registration of marriages. And the requirements of concluding marriages and concluding monogamous marriages, polygamous marriages, and so forth, again, goes totally against what we aspire to. So, for example, and in this instance, I'm going to refer to
Sure.
to the bill that's here in front of me. Is that one of the provisions of the marriage bill, and you've seen in the media in the last few weeks, people were going crazy on WhatsApp and social media to please put in objections because as Muslims we cannot allow this to happen. But I don't think everybody has got a full understanding as to the intimate details as to why we cannot allow this to happen. So I'm just going to give you a few examples for the viewers to get a greater understanding if they didn't read the draft marriage bill. So we know that it's never too late to still make those submissions. I think the deadline has passed, but so we can still try. So the first requirement would be that to enter into a marriage, couples, both of them need to consent to the marriage, right?
Okay, but isn't that generally what happens with Muslims? Or is there times where there's no consent between the two?
No, so that's generally what
Yeah.
happens.
Okay.
However, what happens now in the past and what's been happening for forever in time, as far as I can remember, is that your dad goes with two witnesses to the
Yes.
masjid and all the males attend and the nikah is performed in the masjid. And that's where they sign the register and everything is done. And then they come home and they take the bride and they go to wherever they need to go. Okay? What the bill requires is that the wife must be present at the time of the nikah.
Okay.
So our practice generally is that women don't go to the masjid.
Yeah.
So, and again, this is what the bill presents. It's not necessarily, what I am putting forward. So the woman needs to be present there with the two witnesses. And one of the objections raised to that is that many nikahs will not, because women don't go to the masjid, a lot of women would not want to go. It's taking away the sanctity of the marriage and taking the event out of the masjid, because then they would conclude it maybe in the hall where the wedding is taking place or in a private setting, which is not the way we did things previously. So that has been one of the points of contention. The other point of contention was that if a man wants to enter into a polygamous marriage, then having more than one wife, then there's certain procedures that you'd have to go to. And one of the main requirements of that is that he gets the permission of the first wife, which we know that there are many schools of thought, and there's a lot of diverse opinions on this issue. But the prevailing opinion is that you don't require the consent of the first wife. However, you need to inform the first wife. So that's the other gap in between what they're trying to achieve and what Islamic law actually dictates. Not only does he need the consent of the first wife, but if there's anybody, it goes further to say that if anybody wants to object to the marriage, you can object to it, and a marriage officer will then have the right to determine as to whether this marriage should be solemnized or not.
So the objection can actually happen on the day of the nikah.
Yes, it can.
Okay.
So-
Is there any more that you've picked up? Yeah.
Yeah, so look, there's a lot. Just to go back to, we spoke about consent.
Yes, yeah. I wanted to touch on that, yeah.
Yeah, the consent also is that, coupled with consent also is the age that spouses can get married. That's regulated in the bill. And they have regulated it at the age of 18, whereas from a Sharia perspective, the prevailing consensus is that when a woman reaches the age of puberty, then she's allowed to perform nikah and get married. It's now been regulated or been attempted to regulate that she must be at the age of 18. So that again poses a huge problem in terms of whether even if the father of the bride consents and she's under the age of 18, he will be liable to a criminal offense.
So there's a lot of deeper lying issues to this.
There's deeper lying issues.
And this is of course where you as a Muslim legal professional, along with many others, are going to go ahead and have those opposing arguments lodged against it.
So there's been countless of opposition to the marriage bill for good reason. What was one of the most striking clauses in this proposed draft also was that a marriage, an imam that's concluding the nikah has to be a registered marriage officer with the Department of Home Affairs. And if he's not a registered marriage officer, then he would be liable to imprisonment or fine.
What would be the charge, Farhana? If you, on the top of your head, do you know what the charge would be?
So I would assume that he's not a marriage officer.
Tantamount to fraud, probably.
I wouldn't say
Or
fraud,
something lighter than that,
Yeah.
So, I mean, when listening...
He would be in contempt.
Contempt, yeah.
Or contravention of the act. So it would be more, a charge of contempt. So, again, we have an imam that comes and concludes the nikah and signs the register, and that's that. What they're aiming to achieve is that every Muslim marriage must be registered with the Department of Home Affairs. And my understanding is that the only way they can do that is if every person that performs the nikah is a registered marriage officer. And in the absence of him being so, to get everybody to register, they will impose a penalty on that person or a period of imprisonment.
After the break, I wrap up my conversation with attorney Farhana Ismail. We'll be, of course, just hearing the closing remarks with regards to the draft marriage bill and its way going forward. Do stay tuned. Welcome back to Talking Point. We are wrapping up the conversation with regards to the current status of Muslim marriages in South Africa and the proposed way forward. Now, Farhana, this is a draft bill. It needs to pass the National Assembly and it needs the 2/3 majority, as we have seen how things operate in the executive. I'm assuming you're hoping this does not go through, but given the fact that 2/3 of the majority within the National Assembly are not Muslim, they are, of course, of different faiths. So the possibility is that it will go through. If it does go through, our judiciary allows for there to be appeals and, counter arguments to that. Do you foresee that being the case?
Appeals in respect
to the marriage bill, the change of the marriage bill. I mean, if it does go through the marriage bill that has been drafted,
Look, there's been a lot of opposition to the bill currently. It's left to be seen. There is a general consensus and feeling that it's going to be passed. It's inevitable. What we're left with is when parties do go to court, will be that appeal process and review process that people may choose to exercise. However, remember that if a Muslim marriage is being adjudicated upon in a court of law, you also need people with the requisite expertise that will be presiding over the matter. I'm not sure how they plan to overcome that hurdle. And I'm hoping that many of our Muslim professionals in the legal fraternity will then step up and fulfill some of those roles. But as I said at the beginning of the show, when a divorce happens, the court looks at a variety of factors and relevant circumstances that took place at the commencement of the marriage, during the marriage, and toward, right up until the date of divorce. And again, I stress, in my closing to conclude this matter, that a lot of this can be alleviated if parties enter into the nikah contract with the right guidance. That document will then have to be looked at and given due consideration at the time of the divorce. Because one of the factors in the Divorce Act, when courts are determining an equitable and just distribution of assets and maintenance, they look at any written agreements between the parties or any other relevant circumstances at the time or factors that would allow the court in arriving at a fair decision. So again, my appeal to the South African public at large, to our ulama, to all our imams, marriage officers, is to advise not only the woman, but the men as well, as to what are their rights and obligations at the commencement of a marriage, and to get those necessary nikah contracts in place, which will then assist us in not taking our matters to the South African courts of law, where there's a huge danger that they will overrule the provisions of our Quran and Sunnah.
Farhana, now up until when the date of the bill being passed, again, we don't have a timeline as to when it's going to happen.
There is a timeline.
Is it, what is the official timeline?
Well, not the bill, but remember the bill is a stepping stone. Because in the judgment, the SCA judgment that we spoke about earlier on in the Constitutional Court judgment, they have given Parliament, it was initially a period of 24 months. I think that has been extended, within which to amend the current legislation or to enact new legislation to address the issues and the recognition of Muslim marriages. The marriage bill now is a stepping stone towards that. It's the enactment of new legislation. Unfortunately, it's not what is the best solution for us currently, and hence the opposition to the bill.
Yeah, I was going to ask about education. How important is it from now up until, that bill, the decision is made that education about marriages and getting into it from a contractual basis is being taught by those who have the knowledge from a deen point of view, but also from a legal point of view?
Look, it's extremely important. There are many organizations, counseling organizations currently that offer premarital counseling, and there's certain legal aspects that are associated with the premarital counseling at this stage. Look, not everybody has got the time. It's more of education forms part of social upliftment. I'm not sure how many legal professionals would go out there and actually, go on these huge drives. But the way we can come around that is that any a Muslim couple that wants to get married, families can approach every family has got an attorney that's in the family or gives them advice, or look for reputable attorneys, make appointments, go and sit down with them. There's also many ulama that are very clued up with the current legislation, because it affects the ulama to a large extent as well, insofar as how the Sharia provisions are going to be curbed if the bill does get passed. So I would suggest that people take it upon themselves personally Nobody's going to come to you with
Yeah.
an education education drive. People take it upon themselves. If their sons are getting married, their daughters are getting married, they need to have these discussions with the in-laws
Yes.
before the marriage happens. The discussions don't only relate to the wedding. It should relate to if the girl owns property, does he own property? If they're both working, what would be how would they run their life going forward when it comes to children, when it comes to inheritance. All of those factors should be discussed with the prospective couple. So, Allah forbid, if the marriage doesn't work out, they've got a document that regulates what they would do in the event that it doesn't work out.
Farhana, to wrap up the conversation with the final question, we make dua to Allah subhanahu wa ta'ala that the bill does not go in favor of that two-thirds majority. I know it's going to be a long shot for that to happen, but if it does get passed, how does that then change Muslim marriages, and how do we as South African Muslims look at things now from that perspective? Of course, there will be appeals, there will be arguments against that. We can see the Muslim legal professionals of South Africa going to court to try and challenge this. But in that time, when it is passed, I mean, how does that change things, and how do we as Muslims now need to view marriages from an Islamic perspective, of course, but now also from a South African perspective?
If the bill gets passed, already currently we're subject to, pending the outcome of the
Yes.
legislation, we're subject to the Divorce Act and the Marriages Act. So what that will mean is that we will have to follow the South African law as it stands in terms of marriage and divorce. As Muslims, ultimately we're guided by our conscience.
Yes.
And I think that if we aspire to that, then the outcome can be very different and it doesn't need to be taken to a court of law. But human nature is such that, we know that it doesn't always necessarily, not everybody is willing to do the right thing at the right time.
Yeah.
And it's a difficult question. We also can't judge anybody.
Yes, I'm sure.
We don't know why certain people do certain things, what are their intentions, what are their motivations, what is the background of such a decision. So until then, we are subject to the laws of the land. We don't have a choice. We won't have a choice to elect whether we want to follow it or not. We will be bound by it.
Farhana, would I say Jazakallah, thank you so much for joining us, and again for sharing the knowledge with regards to this. I know you wanted a lot of time for this, and hopefully our viewers have been given that the necessary education with regards to this. And inshallah, we hope to have you soon on one of our shows when, of course, this decision is made. Jazakallah so much for joining us.
Jazakallah for having me.
Assalamu alaikum wa rahmatullahi wa barakatuh.
Walaikum salam wa rahmatullah.
That is attorney Farhana Ismail. She's a specialist, a legal specialist in divorce and family law. We hope you, the viewer, have been educated with regards to this topic, because it really is a topic that needs a lot of in-depth analysis and a topic that requires a complete holistic understanding with this. That's how we wrap up Talking Point today. From myself, Fahraaz Patel, and the rest of the team in Johannesburg, we say Jazakallah to you for joining us. Assalamu alaikum wa rahmatullahi wa barakatuh.